Good morning. This is Bor Yang from the Human Rights Commission. I am an administrative law examiner, and my job is to investigate cases of discrimination, including harassment cases, in state employment, housing, and places of accommodations, which includes schools. Thank you for joining us today for this presentation on bullying and harassment in schools. What do I need to know, and what can I do to address these behaviors? Before we get started today, I just want to say that I will be taking questions at the end of the presentation. However, if you have any clarification questions, please feel free to type those as we move along as well. So the agenda today is dealing with talking about students with disabilities and what laws exist to protect students against bullying and harassment. We'll be talking about the difference between bullying and harassment, the relationship between FAPE, which stands for Free Appropriate Public Education, and bullying and harassment laws and policies. We'll be discussing the responsibilities of a school in dealing with bullying and harassment, and particularly as it relates to students with disabilities. And I'll be reviewing some prevention strategies for schools, for parents, and advocates. First, I want to talk about an important case called TK and SK individually and on behalf of LK versus the New York City Department of Education. And this case came out of the Second Circuit Court of Appeals, which is relevant to all of us who live in the state of Vermont. LK was a child with a disability, is a child with a disability under the IDEA, and she spent the third grade in public school operated by the New York City Department of Education. LK had made progress throughout the school year and performed at or approaching grade level in all of the subjects. However, she was severely bullied, and she had complained about the bullying on a daily basis. Some examples of the bullying include one time when a student pinched LK hard enough to cause a bruise and stomped on her toes. Her classmates ostracized her, backing away from her to avoid touching her. In one instance, they refused to touch a pencil, treating it as it was contaminated merely because LK had touched it. At other times, they pushed her away, they tripped her, laughed at her, they called her names such as ugly, fat, stupid. One student drew a demeaning picture of her, and another even made a prank phone call to her home. Her teachers appeared to have done very little to stop the bullying. When LK's classmates refused to touch the pencil that she had touched, one of her classroom teachers foolishly reinforced their behavior by labeling the pencil with her name on it, purportedly because of her poor hygiene. When she was tripped, another teacher berated her and stated that she was, quote unquote, making a scene. When two of her special educators stated that the teachers were ignoring their concerns about the bullying, the teachers in the school did nothing about that. LK's pediatrician even observed that her teachers neither intervened nor punished any of the students that had been bullying her. Her parents described her as being emotionally unavailable to learn, and special educators noticed that the bullying negatively affected LK's ability to initiate, concentrate, attend, and stay on task with her homework assignments, and she was observed to be volunteering a lot less. She counted the days until school was over. As a result, her parents made several attempts to raise the issue of bullying with LK school, but they were consistently rebuffed. Without avail, they requested copies of any incident reports involving the harassment. They wrote to teachers and administrators about the bullying, but received no response. The school stonewalling continued even during the process of developing LK's IEP. At several of the IEP meetings, LK's parents attempted to raise the bullying issue, but the school principal flatly refused to discuss the issue with them. School officials contended that it was an inappropriate topic to consider when developing her IEP. Being, obviously very upset about the way the school was responding to the bullying of their daughter, the parents then notified the department that they were going to be rejecting LK's IEP plan and in favor of private placement. And later on, the parents sought tuition reimbursement for private school. They went up the chain through the administrative hearing process. And at both of the administrative process, the hearing officers rejected their request for tuition reimbursement. Then the parents appealed to the United States District Court, and the district court developed a 4-part test. The district court wanted to know, 1, was she a victim of bullying? 2, did the school have notice of the bullying? 3, was the school deliberately indifferent to the bullying? And did they fail to take reasonable steps to prevent the bullying? And then lastly, did the bullying substantially restrict her educational opportunities? These were questions that the district court wanted answers to, and questions that were appropriately answered by the administrative hearing officers below. And as a result, the district court then returned the case to the administrative officers to review the case based on these 4 questions. When the case was remanded back to the administrative hearing officers and they re-looked at the case, they still decided that they would not provide tuition reimbursement. The parents then appealed again to the district court, and finally at the district court level won the tuition reimbursement. The Department of Education appealed it to the Second Circuit Court of Appeals, and the appellate court affirmed the lower court's decision, meaning that they agreed with the district court's decision to award tuition reimbursement to the parents. This is a really important case in harassment and bullying, especially with regards to students with disabilities, especially because it is, 1, in the Second Circuit, but 2, a case that clearly states that when you don't allow a discussion about bullying and harassment, that you are in fact denying a student with a disability the free, appropriate public education that they are entitled to under the IDEA and 504 plans. So the district court, the appellate court level held that a child with a disability who is severely bullied by her peers may not be able to pay attention to her academic tasks or develop the social and behavioral skills that are an essential part of an education. Bullying can interfere with a disabled student's ability to receive FAPE. Where an IEP substantially is deficient, parents may unilaterally reject it in favor of sending their child to private school and seek tuition reimbursement. And importantly, even when an IEP is not deficient, parents may seek reimbursement if the state fails to afford them certain procedural safeguards. The violations must significantly impede the parents' participation rights to FAPE or cause some type of educational deprivation. And the court concluded that the Department of Education did deny LK FAPE because they violated her parents' procedural rights to participate in the development of her IEP when they refused to discuss bullying during the creation of her IEP, and thus impaired the substance of the IEP and prevented them from assessing the adequacy of their child's IEP. And as a result, the Court of Appeals affirmed the lower court's decision to award tuition reimbursement. When we're dealing with students with the disability and bullying and harassment, it's really important to take a few facts into consideration. Students with disabilities are 2 to 3 times more likely to be bullied than their non-disabled peers. Bullying can negatively impact a child's access to education and lead to school avoidance, so higher rates of absenteeism, truancy, and tardiness. It can create a decrease in grades, an inability to concentrate, loss of interest in academic achievement, decrease in dropout rates. Students with disabilities also suffer from extreme loneliness and depression and are more likely to experience poor relationships with peers. Bullying a student based on his or her disability may be considered harassment under state and federal laws, and it is a civil rights issue. The Individualized Education Program Plans and Section 504 plans are helpful tools to prevent and stop bullying and harassment of students with disabilities. And really important to know is also that 50% of bullying situations stop when a peer intervenes. So a student telling someone to stop is more impactful than an adult giving the same advice. And we'll talk more about this later on when we talk about prevention strategies as well. Let's now review the laws that are relevant in bullying and harassment cases. So starting with federal laws. There are no federal laws against bullying, but harassment is a form of discrimination, and if harassment is based on someone's race, color, creed, sex, religion, national origin, disability, it is prohibited under federal law. This is what we call a protected class or a protected category. If we find that harassment or bullying is based on someone's race, color, creed, sex, religion, national origin, or disability, it is a protected category and federal law prohibits it. The federal laws that apply are Title II of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, national origin, and a place of accommodation. Title VI of the same Civil Rights Act of 1964 prohibits discrimination on the basis of race, color, national origin in a federally assisted program. Title IX of the Education Amendments of 1972 prohibits discrimination on the basis of sex by a federally funded education program. What's also important to note about Title IX is that it also covers cases involving gender stereotypes. So if a student is being harassed because he looks too feminine or she looks too masculine, this can also equate to sex discrimination under Title IX. Title II of the Americans with Disabilities Act of 1990, or what I will be calling the ADA, prohibits discrimination on the basis of one's disability. I have a question here about whether age is a protected class. And yes, but it's not typically found under these federal laws. Age is protected under the Age Discrimination Act, which only protects individuals who are 40 and over in employment. And so age generally is not protected in the Civil Rights Act other than under the Age Discrimination Act. Thank you for that question. Two other really important federal laws is Section 504 of the Rehabilitation Act of 1973 and the Individuals with Disabilities Education Act, the IDEA. These two laws guarantee students with disabilities free appropriate public education, or FAPE, and they address the obligations of public schools to meet the needs of students with disabilities. Disability-based harassment may deny a student equal educational opportunities, constituting a denial of FAPE under Section 504 and IDEA, and may constitute discrimination under the ADA. As we saw in LK's case that I mentioned earlier, a denial of FAPE can occur when a school fails to address the student and parents' concerns about bullying and harassment in an IEP meeting. All right, let's discuss Vermont laws. Vermont has the Public Accommodations Act, which prohibits discrimination on the basis of race, creed, color, national origin, disability, marital status, sex, sexual orientation, or gender identity in a place of accommodations, and schools are considered places of accommodations. Vermont has also adopted a comprehensive policy on bullying, harassment, and hazing. Additionally, Vermont statutes regarding the discipline, suspension, and expulsion of students allow schools to provide appropriate discipline in cases of bullying and harassment. Let's talk about bullying and harassment and the differences between the two. What is bullying? Bullying is an overt act or combination of acts, including an act conducted by electronic means directed against a student by another student or groups of students which. Before I move on, I want to point you to the words overt act or combination of acts. This typically means that it has to be something more than ignoring another student or not answering maybe questions by a student. It has to be something that is overt or specific. It also includes cyberbullying. So when a student is being bullied through text messaging or social media, that's also part of the definition. And also want to point you to the fact that this has to be between student and another student. So bullying would not cover adults. It is between students or groups of students. Moving on, bullying has to be repeated over time. It has to be intended to ridicule, humiliate, or intimidate the student, and must occur during the school day on school property, school bus, or at a school-sponsored activity like soccer practice or band practice or plays that may be off-site but are sponsored by the school. It can be before or after the school day as well, as long as it's a school-sponsored activity. It can it does not necessarily have to occur during the school day or on school property, such as a school bus or school-sponsored activity, as long as the bullying poses a clear and substantial interference with another student's right to access educational programs. This is really important, especially because when bullying happened, maybe even 10, 15, 20 years ago, a student who was being bullied, a victim of bullying, really could escape the bullying when the school day was over. But now with social media sites and textbooks, text messaging, and YouTube sites, and more, we find that victims of bullying really have no escape, and that the bullying can occur, and sometimes worse, via cyberbullying. And it can, in fact, pose a clear and substantial interference with their right to go to school. And that's sort of important to capture that in the laws and statutes on bullying. Compare bullying with harassment. Harassment is an incident or incidents of verbal, written, visual, or physical conduct, including conducted by electronic means, based on or motivated by a student's or a student's family's members' actual or perceived race, creed, color, national origin, marital status, disability, sex, sexual orientation, or gender identity, that has the purpose or effect of objectively and substantially undermining and detracting from or interfering with the student's educational performance or access to school resources, or creating an objectively intimidating, hostile, or offensive environment. When we look at harassment, note here that it says incident or incidents. So it can, in fact, be one time that can equate to harassment, and it does not have to be repeated. As long as that one incident is sufficiently severe, pervasive, or persistent as to interfere or limit a student's ability to participate in or benefit from the services, activities, or opportunities by a school. It is important to note that case law has stated that, like, an offensive comment made here or there, although wrong, although maybe discriminatory, is not sufficiently severe or pervasive to really interfere with someone's ability to participate in or benefit from the services offered by a school. I want to just sort of review quickly the differences between bullying and harassment again. So, bullying has no federal law protection, but harassment does. Vermont protects against bullying and harassment. Bullying requires that it be between student to student. Harassment can cover student to student as well as students and adults. So a teacher could not really be considered bullying a student, but a teacher could be harassing a student or a staff member or another adult. Bullying can be for any reason, such as someone's weight, the clothes that they wear, where they live, if they're poor, their height, their age, or their hair. However, harassment has to be based on someone's actual or perceived membership in a protected category that I've mentioned earlier. Notice here that the terms actual or perceived are highlighted because it is possible that someone is being targeted because he appears to be of a certain race or sexual orientation, even if he does not identify as that, belonging to that race or that being of that sexual orientation. Bullying and harassment laws cover students who might be bullied or harassed on and off school property. Bullying has to be over a period of time and is repeated, whereas harassment can be over a period of time and repeated, or a single severe incident, depending on the impact on the target and whether it is severe or pervasive enough. Let's review some examples of bullying and harassment. So Bobby is 12 years old. He lives with his mom and 3 siblings in a 2-bedroom apartment. Sometimes Bobby wears the same clothes 2 days in a row. Outside of school, another student, Alex, has been texting his friends, posting messages on Facebook, making jokes about Bobby, his clothes, and apartment. Being that Alex is very popular, many students at school have received these messages. Bobby is uncomfortable going to school and starts to miss school. So sort of make note of, this is a school case, and what is Alex making fun of Bobby for? The fact that his clothes look poor, and where he lives. Although not harassment, these acts may constitute bullying. They are student to student, they are repeated, and although are off campus, they could cause a clear and substantial interference at school, and in this case has already done this. All right. Lori has a disability and sits in a wheelchair. After spring break, she returns to school wearing a new, very short haircut. Someone in her class calls her Professor X from X-Men. This is a bald professor who sits in a wheelchair from the movies and comic stories. And the entire class laughs. The teacher notices, but she ignores it. This is not bullying because bullying must be repeated. We have no evidence here that this has occurred more than once. It's not harassment because although the comment does have something to do with her wheelchair as well as her haircut, it probably does not rise to the level of purpose or effect of objectively and substantially interfering with the student's educational performance or access to school resources or creating an objectively hostile or offensive environment. It's a I would say maybe a discriminatory comment, maybe a really rude comment, one that should not be tolerated in schools, but certainly not one that a court would find severe or pervasive enough to meet the standard of hostile environment. Sarah is a 15-year-old sophomore who has a learning disability. She has a 504 plan. Her social studies teacher, Mr. Reynolds, thinks that Sarah is not really disabled, but does believe her to be dumb. He has said often in front of other kids, Sarah, don't be so stupid. Sarah, that's not a very smart answer, is it? This has been going on for about a year, making Sarah feel bad about herself. Pay attention to who is making the comments here. This is not bullying because it is not between a student and another student. However, this may constitute harassment since it is based on her disability and it has the effect of objectively and substantially interfering with her educational performance. This is a teacher. This makes her feel bad about herself. Sarah may not want to come to school, and it's been going on for a long time as well here. Had Mr. Reynolds made this comment only once, it probably would not be sufficiently severe. Fatima is a middle school student who is blind and walks with an assistance cane. She rides the school bus. For over a month, another student, Jason, and his friends have been throwing random objects on the ground as Fatima enters and leaves the bus. Fatima has not fallen yet, but she is aware that Jason and his friends are doing, and she hears the laughter of other students. Although the acts constitute bullying, it's important for the school to understand that this also rises to the level of harassment. Again, yes, it's repeated, intended to ridicule, humiliate, and intimidate, which makes it bullying. Jason here is targeting Fatima based on the fact that she is blind. It is based on her disability, and it is creating an objectively hostile and offensive environment. And it is impacting Fatima's ability to access educational opportunities. So we can see here that this is a case of harassment because it is based on disability. All right. Let's talk about free, appropriate public education. FAPE, states and school districts have a responsibility under Section 504, IDEA, and ADA to ensure that FAPE is made available to eligible students with disabilities. Harassment of a student based on disability may decrease the student's ability to benefit from his or her education and amount to a denial of FAPE. Now, I want to also really be clear here that harassment or bullying can constitute a denial of FAPE, not just harassment itself. So if a student with a disability who qualifies for IDEA or 504 services is being bullied, but not necessarily harassed, so the bullying is not necessarily based on their disability, it can still trigger the same concerns that would require an IEP and 504 team to consider and meet to discuss plans, or maybe even revising the 504 plans and the IEP plans for the particular student. Let's sort of talk about the flow chart for understanding FAPE and harassment and bullying. So the first question to ask is the behavior based on the targeted child's membership in a protected class, for example, their disability? If the answer is no, then the school must investigate the bullying. However, the school should still also ask, is the student on an IEP or a 504 plan? If the answer is no, then they proceed with the investigation of the bullying, and that stops that. And we'll talk about the investigation process in a few minutes as well. Going back to the first question, if it is based on a disability, it seems here that this is probably a case of harassment. The school should also be asking, is this student on an IEP and a 504 plan? If the answer is yes, if a student is on an IEP or a 504 plan, the school needs to refer the case to a case manager for analysis. At the same time, so simultaneously as the team is, or the case manager is reviewing this case, the designated employees must also be investigating the bullying and the harassment. It is not that you refer to the IEP team or 504 team, and that meets the requirements of the law. The laws require that both occur simultaneously, an investigation as well as analyzing whether or not this behavior has impacted FAPE. When the case manager is trying to decide whether or not to convene the team in these cases of disability harassment or bullying, these are the important questions to ask. Have the student's needs changed? Does the student have a different or additional needs? And if the answer is yes to any of these questions, the case manager should have the team meet to rewrite the plan. Some of the things that a case manager and a team should look at are, has there been any decline in grades? Have there been an onset of emotional outbursts? Is there an increase in frequency or intensity of behavioral interruptions, or a rise in missed classes or sessions? So if you have a student who is on an IEP and 504 plan, and there have been instances of being bullied or harassment, if it looks like they're missing class or running late to class, or a student who normally is volunteering seems to be shying away from that, these are important considerations for a team to look at when deciding whether or not to rewrite the plan. the courts would consider any of these things like declining grades or emotional outbursts or behavioral interruptions to be sufficient to rewrite the plan. Unless it is clear from the school's investigation into the bullying or harassment that the conduct had absolutely no impact on the student's receipt of FAPE, the best practice is always to promptly convene the IEP or 504 team to determine the needs of the students, whether they have changed, and whether FAPE has been impacted because of the bullying and harassment, and whether there are additional or different services that are required. Although the IEP and 504 team can address harassment or bullying for the target, this is the student who is being harassed or bullied, IEPs and 504s cannot address the behaviors of the perpetrators. This is why it's important for the investigation to move forward so that they can address the behaviors of the perpetrators. Let's talk about a school's responsibilities. A school has a lot of responsibilities, but I try to categorize them in a way that would make the most sense. Obviously, schools have a responsibility to adopt a policy on bullying and harassment. They have a responsibility to investigate reports and then to take prompt and remedial action. Let's review these in depth. Adopt a policy. Vermont's policy on bullying, harassment, and hazing that I cited earlier specifically states that a superintendent or designee shall adopt a procedure directing staff, parents, and guardians on how to report violations and file complaints. A superintendent and designee must select 2 or more designated employees to receive complaints and publicize their availability in any publication of the district. And they have to also designate an equity coordinator to oversee implementation of the policy. This can be one of the 2 designees. So they have to adopt a policy on bullying and harassment. That policy has to be clear in how parents, guardians, and staff can report violations, and that policy has to be publicized so people can see the rules and the procedures and standards of conduct. And there has to be 2 designated employees. I also want to point you to the fact that the Department of Education in the state of Vermont has put out a brand new list of the designated employees at each school, and it is on their website. So please go to that, the Department of Education's website, the Agency of Education's website, to look at that list of designated employees. Another very important responsibility of the school is to investigate reports. It is really important for staff members, teachers, and parents to know that it is not a staff's responsibility to make a determination as to whether a violation of bullying or harassment has occurred. It is not up to them to decide that it is bullying or harassment before they report. It is the responsibility of the designated employee to investigate the complaint. And the job of staff to report incidents of possible alleged harassment and bullying. If a school employee overhears or directly receives information about conduct about bullying and harassment, they have to immediately report the information to the designated employee and complete a student conduct form. If a school employee actually witnesses actions that could possibly be harassment or bullying, they have a responsibility to prevent the reoccurrence and to stop the action from happening as they see it immediately and immediately report it. A superintendent or designee shall respond to notifications of possible violations and promptly and effectively address complaints. And again, here, notifications can be written complaint or oral information. But please note that the laws on anti-discrimination state that in fact notice can occur when an employee or someone who a student believes knows or should have known about the bullying and harassment occurs. So this standard or this requirement of knows or should have known is in fact part of anti-discrimination laws. And that's important for school personnel, for teachers or staff members, anyone who works at a school to realize that even knows or should have known could potentially be sufficient notification under harassment laws and anti-discrimination laws. All right, let's look at this process just a little bit more. So a report is made by a student or a witness or a parent, adult, school employee. It goes to the designated employee. He or she receives the report. They have to put the complaint in writing, even if it comes to them orally. They have to notify the administrator, which typically is the principal. They have to send out sets of copies of policies to both parents and set up a safety plan if appropriate. We'll talk about the safety plan in a few minutes. The designated employee also has the ability to decide if an alternative dispute resolution is appropriate or whether to conduct an investigation. And again, I have other slides on ADR as well and when that would be appropriate or not appropriate. The designated employee has an obligation to do the investigation within 1 school day and finish it within 5 school days. After they are done, the investigator files a report with the principal and administrator with an initial determination. Now, if that initial determination says that bullying and harassment has been substantiated, it is up to the principal and the administrator to decide the discipline and notify the parties, as well as following up with the target. This is the victim of the bullying and the harassment periodically. It is extremely important for designated employees to document the complaint, including the time, place, nature of alleged conduct, and identify any individuals and witnesses, as well as set out the proper notices about language and retaliation, being that retaliation is prohibited by laws and policies. The complainant and the alleged perpetrator have the right to present witnesses as well as other evidence in support of their position. When the designated employee makes an initial determination, that is considered a student record and it is confidential. Parents are informed that a policy on bullying, harassment, or hazing may have been violated, but they are never told about the specific conduct because it is a student record and it is protected by law. Also important to note here that if the bullying and harassment is not substantiated, there is notice to the parents of both that fact and along with copies of the policy. If a parent of a target student, a student who has been a victim of bullying and harassment, is unhappy with the school's investigation, they have the right to request an internal review by the district or a right to request an independent review, but they have the right to request that independent review only within 30 days of the final determination. And we'll talk more later about the independent review as well. And parents also have the right to file a complaint with the Vermont Human Rights Commission or the Office of Civil Rights in Boston, Massachusetts. I said I'd return to some of these topics that I kind of went through fairly quickly, the safety plan, ADR, and independent review. Let's talk about the safety plan, developing a safety plan. Schools should consider a safety plan if a target says he or she does not feel safe around the alleged perpetrator, even if an investigation is incomplete and harassment has not been substantiated. It's always smart, good, just to create a safety plan when a student feels unsafe, whether or not that investigation plan has occurred. That is why it's important for the designated employee to consider the safety plan early on, as soon as he or she receives the report of the bullying and harassment. If there's been any kind of physical or sexual assault, that safety plan has to be set up immediately. Safety plans are also things that can be attached to an IEP or a 504 plan, and it is the best way to keep documentation of the safety plan. And where appropriate, a school needs to notify the police or the Department of Children and Family Services. What can a safety plan include? Safety plans can include setting time frames for implementation and review. They can move the alleged perpetrator out of classes with the target, unless the target has requested move. Extremely important to note that it is not okay and not good to move the target student from a classroom or from a playground or from the cafeteria because she or he is complaining about bullying and harassment, and that it is actually, in fact, better to remove the alleged perpetrator unless the target student actually asks to be moved. Assigning an adult to monitor is helpful. Setting extra or focused supervision in open areas like cafeteria, library, playground, hallways. And this doesn't have to be even an employee or someone who has knowledge about harassment or bullying. This could be asking parents to volunteer during recess, during lunch hours, lunchtime. That would be important as part of a safety plan. Removing the alleged perpetrator from the school contacts like school bus or sports teams, establishing sort of a yellow zone for the playground so that the perpetrator must remain during the recess, identifying a safe adult at the school that the target trusts and she or he can report additional incidents to, checking in with the target student on a regular basis, not waiting for the target to report to the adult. Eliciting the cooperation of the alleged perpetrator's parents and holding their child accountable, identifying a student buddy for the target, delaying the release of the alleged perpetrator from class or after school to prevent contact. This could be as easy as 5 minutes. And these are things that can also be done without drawing attention to the fact that they are happening, so that other students don't necessarily have to know that. If appropriate, addressing the issue of keeping students safe while walking to and from school, and also making sure that safety plans include a clause reminding the target that retaliation is prohibited and reminding the perpetrator as well that retaliation is prohibited. Alternative dispute resolutions. The appropriateness of ADR or in some other type of informal resolution highly depends on the nature of the incident, the age of the students, the agreement of the complainant, the nature of relationship between parents, history of the alleged perpetrator, whether either party has a disability that impacts behavior, whether there is a significant power imbalance between the parties. For example, ADR would not be appropriate if we were dealing with a teacher versus a student, or a student with a disability who may not be able to communicate or who may have trouble communicating or advocating on his or her behalf. ADR may not be appropriate if this is a student who has if the alleged perpetrator has already committed acts of bullying or harassment in the past, and ADR has not been fruitful in the past. ADR might be more helpful if you are dealing with students who are older and able to communicate well and advocate for themselves. ADR is also a little bit more helpful if we're dealing with an incident that maybe is not as severe or serious, maybe comments that have been made, something like that might make sense. It is very, very important that if a school chooses to do ADR, that it still documents the resolution, it notifies parents of the outcome, and it gives copies of the policies to both sides, and reporting the data, as well as following up with the target to periodically check on whether or not the harassment or the bullying has stopped. Another important school responsibility is taking remedial action. It is important for a school to take prompt and remedial action on substantiated complaints. If a student is found to have violated the policy on bullying and harassment, and expulsion is recommended, the school board has to approve of that expulsion. Any student who is going to be suspended or expelled also has the right to an appeal and an appellate process. If an employee, such as a teacher, has violated the harassment policy, school has to also follow their collective bargaining agreement, as well as state and federal employment law for termination or suspension. And an employee also has the right to appeal as well. Here are some strategies for schools. Prevent, prevent, prevent. Research across 25 years have shown that school bullying prevention programs actually make a difference. They can lead to changes in knowledge, attitude, and self-perceptions. Anti-bullying programs are effective as long as they engage the entire school community. School-wide strategies and intensive strategies for certain students who have misbehaved are helpful. Some of the things that schools can do: conduct anonymous surveys to assess the extent and nature of bullying in schools. Hold conference days on bullying and harassment problems. Increase supervision during recess, lunch, hallways, bathrooms. They can do this before a safety plan is in place. Establish a contact telephone where students and parents can call anonymously to report, discuss bullying at school. Conduct meetings with parents to discuss bullying. Establish a teacher group to address school climate issues. Involve students in actively addressing bullying. Peer-to-peer prevention strategies work well. Providing lots of trainings to staff. Collecting data, monitoring and seeing if there are trends. Following up on incidents immediately, whether or not they result in bullying and harassment, and modeling good behavior and teaching good behavior at schools. These are all really important tools and strategies for schools to prevent bullying and harassment from occurring. Some strategies for teachers. Establish class rules against bullying. Have regular class meetings to discuss bullying issues. Have students participate in role-playing activities, read literature about bullying situations, or even about just differences and acceptance. Utilize cooperative learning activities. Discuss bullying at general parent-teacher meetings with student involvement. Let's talk about strategies for parents. If your child uses the internet, set up mechanisms in your home to monitor the use and talk to him or her about using the internet safely. Talk with your child about bullying and harassment. Talk with school staff if your child has told you that he or she believes they have been bullied or harassed. Understand the difference between the legal definitions of bullying and harassment. Read and understand the school and supervisory union's harassment and bullying policies. Take good notes and keep copies of correspondence. Ask the school, adopt a safety plan if you believe your child has been bullied or harassed. Request that the IEP or 504 meeting take place and review the impact of the bullying or the harassment on the student, your child. Request an independent review. Again, this independent review must be in writing and given to the superintendent. So I said I'd talk about independent review, and I want to do that at this point. One of the very helpful tools for parents is the ability to ask for an independent review. It is only available to parents and children who are the victims of bullying and harassment. An independent review is not available to students who are alleged to be perpetrators of the harassment or bullying. An independent review occurs when there's an allegation of harassment and the complainant is either unhappy with the final determination that the harassment occurred, or they believe that although there's a final determination of harassment, that the school's response was inadequate to correct the problem. So let me just say that again. A parent can ask for an independent review. That typically has to happen within 30 days of the final determination. A parent can ask only if that child is the victim of the harassment. The harassment, the basis for the independent review has to be that the school has not found harassment, or although the school found harassment, the school's response was inadequate to correct the problem. It can be a very helpful and useful tools. And the Vermont Human Rights Commission, as well as the Agency of Education, work together in creating a list of the individuals who are available to do that independent review. Let's talk about strategies for advocates. Read, understand, and be knowledgeable about the laws and policies around bullying and harassment. Understand the difference between bullying and harassment. Inform parents of designated employees of their schools. Inform parents of their rights to file a complaint with the Human Rights Commission or the Office of Civil Rights. Get regular trainings on bullying and harassment. And my last slide is sort of the agencies that oversee these laws that we've mentioned throughout the presentation. The Office of Civil Rights, the OCR, which for us would be located in Boston, enforces Section 504, ADA, and the ADA rights inherent in IDEA. The Department of Justice enforces ADA, harassment and IDEA violations. And in the state of Vermont, the Agency of Education monitors the IDEA compliance, and the Vermont Human Rights Commission investigates and enforces rights of students in protected categories to be free from harassment in schools, which are considered places of accommodation. Right now, there are no agencies beyond the school or the supervisory union in the state of Vermont that has any enforcement rights or responsibilities for claims of bullying. All right, so let me answer some of the questions that have been raised. So one question is, do you have a list of the designated employees in schools in Vermont? I do not have it, but I did send it to the Vermont Family Network, and I also know that the Agency of Education has that list on its website. And I believe I know who this asker is, so if you email me, I can send you that email as well. The next question is, how many complaints has the Human Rights Commission received this year and previous years? What is the trend up and down? If up, what areas do we need greater focus to improve the situation? I think that's a really great question. Just so you know that the Vermont Human Rights Commission investigates not just school-related cases, but in state employment cases, as well as housing cases, and just overall, generally, we're very busy. And we certainly are investigating discrimination cases very regularly. However, there has been a trend of school discrimination cases sort of going down, I believe, in the last few years. That does not necessarily mean that students are being harassed less. Sometimes that's just a matter of, our parents or schools aware that the Vermont Human Rights Commission is investigating these types of cases? Are students and parents aware of the difference between harassment and bullying? Sometimes I think these trends change for other reasons as well. And so, it's not entirely clear. I hope that answers your question. Next question. If visually impaired child was repeatedly asked to count his friend's fingers by classmate, is this counted as harassment? If it is, how can it be resolved? Okay, so obviously this is an example, and I'll try my best to answer these questions when it's fact specific. And I do also want to refer you to the Vermont Family Network, who can also help answer some of these questions, as well as the Vermont Human Rights Commission, if you believe that your child or a child has been harassed under the harassment statutes. So, so this is a child that's visually impaired, and his classmates are asking him to count fingers, obviously something that he can't do. One, I think the question really is, how often has this happened? Is this causing this particular child a lot of discomfort? Is it making him upset about it? Are the other students teasing him in other ways? Not that it has to be more or less. I mean, I certainly would find that, if this was a one-time incident, that it may not rise to the level of severity or pervasiveness. On the other hand, I do think it's really concerning and something that schools should be addressing. Without knowing more facts, I really can't say, and so I would highly recommend that if this is actually based on what is really happening, to contact the agencies that I've mentioned earlier. Next question. If we look at the example of the pencil and the students not wanting to touch it, how is that different than a student refusing to sit next to a student or refusing to talk to them, ignoring by a large group? Sure. I don't know. I think that's a really great point. I'm not sure that it is entirely different. In fact, that they both may not be necessarily overt. But notice that in LK's case, that wasn't by itself enough. And in that pencil case, not only did the students not want to touch it, they also stated that they believed it had been contaminated, and that the teacher, in fact, labeled that pencil based on her belief or his belief of LK's hygiene. So there was a lot more there than just students refusing to touch a pencil and not saying more or other than that. Is independent review available for bullying? Also, that's a really great question, and I'm sorry that I might have confused you on that. I do believe that the policy on bullying, harassment, and hazing only allows independent reviews for harassment. But give me a second. I want to just double check. I have the policy here with me, and I want to make sure it's accurate while I have you guys paying attention to that. So the rules, the policy on that has been adopted by the Agency of Education specifically states that an independent review can only be requested by a person who has complained that he or she is a victim of harassment. So it would not cover bullying. All right. Is it best for a parent to call for an IEP team or 504 team meeting when they have concerns about bullying or harassment rather than work through the avenues? I think the answer to that question is both. I think that you should work through the regular school avenues as well as contact the IEP and 504 team, especially if you believe that the bullying or the harassment is causing the child with a disability it's impacting his or her education. So if they don't want to go to school or they seem to be really late to classes, sort of dragging their feet in the hallway, or they're volunteering a lot less, those are absolutely sufficient reasons to ask that the IEP team and 504 team convene to discuss whether or not the bullying and the harassment has impacted the student with the disability's right to access education. There's a question here on the time frame in which an investigation needs to be conducted, and then how many days to a determination being provided in writing. I think I mentioned that it's 1 to 5 days. And typically that writing and that notice follows in the immediate week. What are some suggestions on ways an IEP or a 504 plan can assist in preventing bullying or harassment? I think one of the best and most important ways is creating a safety plan, and that we mentioned earlier in the slides, and using some of those tools and attaching that to the IEP and the 504 plan as well. I also think it would be appropriate to ask that special educators who typically work really closely with some of the students with disabilities to sort of be the individuals who might be available for monitoring. An IEP and 504 team can also decide whether or not someone who is part of the team can be the trusted individual that the student can go to report concerns or new incidents of bullying and harassment. Can we get a copy of the presentation? Yes, I'll make it available too. Yeah, it'll be posted on the website the Vermont Family Network's website. Can you define hazing? Unless maybe you already did it and I missed it. I did not define hazing. I specifically actually left out hazing as part of the presentation, particularly because I wanted to focus on students with disabilities in elementary, middle school, and high schools. And a lot of the hazing statutes are really relevant to college age students. I would refer you to the Vermont's policy on bullying, harassment, and hazing, and it has that definition. Let me see if I missed any questions. All right. Do you think that schools who use positive behavioral interventions and supports are more likely to have a positive school culture, thereby having less harassment, bullying situations? Yes, absolutely. And I mentioned it earlier. I didn't use PBIS as the acronym, but I do want to say that studies have shown that when a school adopts an entire culture of role modeling and good behavior, that in fact it has a real impact on the number of harassment and bullying cases or situations that come out of those. Oftentimes, schools that don't take a preventative approach end up taking a compliance approach when something bad has already occurred. And that's really not the way to do it. When teachers and the entire school environment teaches all students how to treat each other with respect, how to be responsible, how to appreciate differences. It really does have an impact on how people's attitudes are about harassment and bullying, and make students feel a lot more comfortable. Does any agency review the school's policies to make sure they are in compliance? You know, I don't know. We, as from the Vermont Human Rights Commission, I know that we would look at the policies as they come up in an investigation, and that if they were not in compliance at that point, that certainly would be something that we would take into consideration in our investigations. My guess is that the Agency of Education obviously oversees that, but whether they have any individual who would be reviewing, I'm not sure. And again, this could just be my ignorance on that topic, not to say that there isn't one who might be reviewing it on a regular basis. All right, I think I've answered all of the questions, and just want to thank you today for joining us for the webinar. This webinar will be archived on the Vermont Family Network's website, along with many other previously recorded webinars. Be sure to visit VFN's website at vermontfamilynetwork.org for a complete list of upcoming webinars, workshops, and support groups. For support and information, call us at 1-800-800-4005. Again, that's 1-800-800-4005. Thank you so much, and have a good day.